I'm not threatening you. Say one more word, and that's 30 days. 30 days.
Hey, what's going on, guys? Welcome back to Sovereign Citizens Hall of Fame with your man TP. Today on the compilation list, we have number 67. And today we're going to be in 3 different judges' courtrooms. And we're also going to add a sovereign citizen traffic stop to the end of these proceedings. Before I give you the rundown on the judges, just know there will be no commentary added to this video. And also there will be chapters added. And thank you guys for all of the support and all of the love you guys been showing the compilation, all of the encouragement to make more. And that's what we are going to do. Now, let me give you the rundown on those judges. The first judge courtroom that we're going to be in is Judge Charles Hart out of the state of Kansas. Second, we will be in the courtroom of Judge Derek Meinecke out of the state of Michigan. And last courtroom that we will be in will be Judge Joseph Lee out of the state of Kansas. And our sovereign citizen traffic stop today will be coming out of Shinnston, West Virginia. Listen, guys, as always, another great compilation. I know you're going to enjoy it. And listen, nothing else to be said. Let's go ahead and jump into number 67.
Next case, State of Kansas versus Sydney Taylor Leslie, 25 CR 250. Good
Yes, Your Honor.
afternoon, Miss Leslie. Miss Leslie, you're charged by way of information on or about May 21, 2025 in Butler County, Kansas, with interference with law enforcement, a Class A non-person misdemeanor. Count 2, same date and location, no proof of insurance, a Class B non-person misdemeanor. Same date and location. Count 3, no driver's license in possession, an unclassified non-person misdemeanor. Though, then count 4, same date and location, failure to register vehicle, an unclassified non-person misdemeanor. And Miss Leslie, do you understand the charges pending against you?
I comprehend the alleged charges against me.
Thank you, Miss Leslie. Miss Leslie, you do have the right to counsel. If you cannot afford an attorney.
Excuse me. I was going to say that I comprehend the certain statutory allegations that have been made against me, but I cannot and do not admit to understanding or accepting the jurisdiction of this court over my person or the subject matter absent proof of corpus delicti and a verified complainant from an injured party. To do so would constitute a waiver of fundamental rights, which I explicitly refuse to waive pursuant to KSA subsection 60-212 in the doctrine of special appearance recognized in Kansas jurisprudence.
Okay. You do have the right to counsel. If you cannot afford an attorney, one would be appointed to represent you. And Miss Leslie, are you currently employed?
For the record, Your Honor, just to start from the beginning, I, Sydney Taylor Leslie, appearing specially and not generally in propria persona, sui juris, as a living woman and not as a legal fiction or corporate entity. I reserve all rights without prejudice pursuant to KSA subsection 84-1-308 and UCC 1-308. Let the record reflect that my appearance today is under explicit protest and duress and solely for the purpose of challenging jurisdiction and preserving my unalienable rights as secured by the Constitution for the United States of America and the Constitution of the State of Kansas. And Your Honor, before these proceedings advance further, I must respectfully challenge this court's jurisdiction in toto and move for immediate dismissal of all charges. I hereby invoke the burden-shifting doctrine established in State v. Shepard in 2009 and State v. Seams in 2004, which places the affirmative burden upon the prosecution to establish by sworn non-hearsay allegations within the 4 corners of a valid charging instrument that every element of the alleged offense and my commission thereof has been properly established. The threshold matter of jurisdiction must be adjudicated prior to any other proceedings. As articulated in Ex parte Young in 1908 and recognized by the Kansas Supreme Court, jurisdiction is the fundamental prerequisite to all jurisdictional proceedings. The legal maxim ex injuria just non autora, law does not arise from injustice, applies to these proceedings in their entirety.
Okay, and the court finds that Miss Leslie is appearing as a sovereign citizen before the court, and the court, once again.
I object to any of that derogatory. It's very biased. I move for immediate dismissal on those grounds and
Court
disqualification.
overrules the motion for dismissal of the case. Court overrules dismissal of the
prejudice
case.
And
the court will find that Miss Leslie, that the court does find it has jurisdiction to proceed, and subsequently the court
I
sets your next
object. You
appearance
called me a
date.
sovereign citizen. I object. You called me a sovereign citizen.
Yes, ma'am.
That is prejudice and bias.
No prejudice or bias is asserted as to yourself. However, the court, as opposed to trying to write down docket notes to that effect, is just recognizing what you are advising the court, that the court has no jurisdiction over you, and based on your statement made to the court. Subsequently, the court does find you've posted a $3,000 cash bond. $3,000 cash bond has been made. Court does accept the same, and the court does schedule this matter next before Judge Webster on Monday, August 11, 2025 at 9 a.m. Monday, August 11, 2025, 9 a.m. before Judge Webster. Once again, Monday, August 11, 2025, 9 a.m. before Judge Webster. You do need to participate by Zoom process at that point. Subsequently, the court finds that Miss Leslie has not requested court-appointed counsel. Court does not appoint counsel at this point. The court does find that she has posted bond in the amount of $3,000 cash, $3,000 cash bond, and the court has scheduled her next appearance date before Judge Webster on Monday, August 11, 2025 at 9 a.m. Any other matters to come before the court, Mr. Sweeney?
No, Your Honor.
And Miss Leslie?
Your Honor, my jurisdictional challenge is predicated upon multiple independent grounds, each sufficient to warrant dismissal. First, I challenge personal jurisdiction pursuant to Kansas Rule of Civil Procedure. I appear specially, not generally, and have not consented to this court's jurisdiction. The record before this court is devoid of evidence establishing proper jurisdiction over my person as a living woman rather than a legal fiction or corporate entity, as distinguished in Hale v. Hinkle in 1906, and recognizing Kansas jurisprudence. Second, I challenge subject matter jurisdiction pursuant to Kansas Rule of Civil Procedure 60-212, B1. No verified complainant from any injured party has been filed as required by KSA subsection 22-2301 in Butler County Local Rule 3.1. The perpetrated charges arise from actions of agents of the state acting under a color of law, not from a legitimate controversy between adversarial parties withstanding as required by Article 3 jurisprudential principles adopted by Kansas courts in State ex rel. Morrison versus Libius. Third, I challenge territorial jurisdiction. The alleged incident occurred after I had ceased operating my conveyance and was exercising my unalienable right to travel, placing it outside the territorial jurisdiction of traffic enforcement under KSA subsection 8-244, which by its plain language applies only to licensees who have voluntarily entered the regulatory framework. Fourth, the prosecution cannot establish the corpus delicti of the alleged offenses. As held by the Kansas Supreme Court in State v. Stern in 2015, the corpus delicti rule serves as a safeguard against convictions based on false confessions or statements. One cannot interfere with a peace officer absent of officer's lawful execution of duties. Where the initial detention was unlawful, as it was here due to lack of probable cause, there can be no derivative crime or of interference. Fifth, the refusal to provide identification is not a crime in Kansas, absent specific statutory circumstances not present here today. This is in support by Brown versus Texas in 1979. The Supreme Court held that detaining a person solely to obtain identification violates the Fourth Amendment absent reasonable suspicion of criminal activity. The principle has been recognized and applied by Kansas courts. In one moment, please, while I gather another statement. Okay, and another thing is, and this is, may it please the court, for the record, I must now enter an oral objection and motion for disqualification of the presiding judicial officer pursuant to Kansas Rule 2.11 of the Code of Judicial Conduct, as well as controlling principles under the Due Process Clause of the 14th Amendment. During a prior proceeding, specifically, that's proceeding, specifically, this court referred to me by the term sovereign citizen, a pejorative classification which carries with its government manufactured implications of extremism, frivolous, and legal irrelevance. This label, unprovoked and unsupported by any factual predicate, constitutes a stigmatizing judicial characterization that violates my right to a neutral and detached tribunal. The use of that term demonstrates either a prejudiced bias or a judicial predisposition toward delegating the substance of my legal posture. As the Kansas Supreme Court has held, even the appearance of partially mandates recusal, and here the record reflects actual prejudice in open court. Wherefore, I respectfully move this honorable court to dismiss all charges with prejudice for lack of jurisdiction, issue a finding that the prosecution has failed to meet its burden of establishing jurisdiction, order the immediate return of all my property seized, including the 251 USD, confiscated and converted to a reloadable Visa card without my consent, order the expungement and permanent sealing of every associated record pursuant to KSA subsection 22-2410, award compensation for the full measure of damages sustained, including costs for my automobile window repair, bail costs, and compensation for unlawful detention and deprivation of liberty, grant such and other and further relief as this court deems just and proper. The breaking of my automobile window without warrant or probable cause of a search of my currency constitutes violations of clearly established rights for which the law provides remedies pursuant to the maxim ubi jus ibi ridium, where there is a right, there is a remedy. I reserve all rights without prejudice, waive none, and maintain my special appearance for the sole purpose of challenging jurisdiction and preserving my alienable rights as secured by the Constitution for the United States of America and the Constitution of the State of Kansas. And thank you for hearing me. I do appreciate you, Your Honor, and thank you for your time.
And once again, matter is set before Judge Webster on Monday, August 11, 2025, 9 a.m. by Zoom. There being nothing further to come before the court is in recess, and have a good day, Miss Leslie.
Thank you, Your Honor.
And Mr. Sweeney, that's the last case I show on the first appearance docket.
Thank you, Your Honor.
Have a good day.
You too.
on Len Stringer, 24-01173.
Good morning, Your Honor. Samira Malus on behalf of the people.
Good morning, Judge. For the record, David M. Sunutko appearing on behalf of Mr. Stringer.
All right, Mr. Stringer, state your name.
I don't acknowledge myself as Len Stringer. I'm a living entity.
Okay, is there another name that you go by, sir?
Living entity, I'm the beneficiary, so I go as a job. And I want to fire that counsel. I don't want him.
All right, so there's a number of things to unpack here. All right, so let's walk through this. I have an individual before me that is listed as an Oakland County Jail inmate by the name of Len Stringer. I have a case that's been assigned to this court that where the defendant's name is Len Stringer. Mr. Sunutko, are you assigned on this case?
I am, Judge.
Okay, and you were assigned to the Stringer case, correct?
That's correct, Judge.
Okay, so that's enough for me to conduct this hearing today. Now let's walk through this. Miss Mount Lewis, have you provided discovery to Mr. Sunutko?
Your Honor, I didn't have an attorney listed. I believe if he filed, he may have just received written discovery. I didn't have that in my information, but give me 1 second to confirm. I'm just going to make one click.
In the meantime,
I do have written discovery, Judge.
So, yeah, it seems that he was provided with written discovery on June 26th.
Okay, so Mr. Sunutko, have you had a chance to talk to the defendant at all?
I did, Judge. I met with him at the Oakland County Jail.
All right, and so
Tuesday.
So did he make it known to you that he wished to no longer proceed with your services?
Judge, we discussed the case fully, and I had a lengthy phone call with one of his relatives, and it was my intention to ask the court to refer this to the Forensic Center for a competency evaluation.
I do think that given your experience and then your connection with him as well as a family member, plus the way the defendant has presented today, that a competency review is in order. And so I'm happy to move forward with that. So Mr. Stringer, there is, just so you understand, there has been some preliminary information that suggests that you may not be competent to proceed at this particular time. Whether that's a correct assertion is basically a decision that can only be made after an investigation is done to determine whether or not you can, that you understand the nature of the proceedings, that you can assist your attorney. We need to find those things out. And so, Ms. Mount Lewis, can you prepare an order for competency review?
Yes, Your Honor.
All right. I agree. I think that that's appropriate at this time. I recognize that the defendant has made a request to have Mr. Sunutko removed from the case based on the information, though, that I've sort of observed at this time, as well as information received by Mr. Sunutko. I remain unconvinced that those statements are anything other than a manifestation of what might be a competency issue. And so I'm gonna wait to consider that request until I can determine whether or not he's competent. If I would remove Mr. Sunutko off the file, if I would remove him off the file based on a request made by a person who's later determined to be incompetent, I think that would be a real issue. And so at this point in time, I'm going to grant the request.
What labels me incompetent? My intelligence, because I have a high IQ?
No. That's not it, sir. There are different legal standards, but really it comes down to whether or not you can understand the nature of the proceedings at this time, that you have the ability.
I oversee the nature of the proceedings.
That you have the ability to assist your attorney in
And
your
I
defense.
to withdraw, sir. I do not want my legal counsel. Actually, he did not reach out to the person that my relative told him to reach out to my father. and he didn't do that. My father was going to tell him that we wanted him to withdraw. He did not reach out to my father. He only reached out to Stephen Taylor. Stephen Taylor gave him my father's number, and he did not do that. So I would like him to withdraw from my case, sir. I have no. So he doesn't. He isn't competent enough for me, honestly.
So I do have, in addition to the information that's been provided, I have a recommendation from pretrial services that suggests that there are untreated mental health concerns, and the nature of his criminal history and criminal contacts suggests that there may be significant mental health, untreated mental health issues. So, Mr. Stringer, I've heard your concern at this time. I'm not going to grant your request until I get a better idea of what your current mental health status is. So the request at this time is denied, but I will consider it again after an evaluation is done.
Hey, so who is the judge on my mental health? Because you can't obviously be a judge because, sir, I'm with my law, sir. So first off, I do not acknowledge myself to be Lindell Stringer, the corporation in capital letters. No, sir.
I appreciate that, and that's why I let you make a record, and I appreciate that. I just, based on what I've seen, I disagree with your position right now, and we'll get you evaluated.
You cannot.
That's enough for now, and then we'll have you evaluated by the evaluated by the forensic center, and we'll go from there. Thank you, Mr. Zanuko. Bond is continued.
Do we have a new date, Judge?
We'll set it 90 days out.
Very good. Thank you, Judge.
Thank you.
All right, the next matter is State versus Isaiah Curvin, 24 TR 17. There's a name of Isaiah Curvin on the screen. Please turn on your monitor.
I'm here.
Mr. Curvin, is the headgear you're wearing a religious item?
It's a cap. I'm outside. It was snowing out here. I'm in Oklahoma City. I'll take it off in a second. That's why I got my jackets on. Yeah, it's kind of cold outside. No problem. Yeah.
Thank you. All right. This is your first appearance. We were scheduled for an earlier date. Mr. Curvin did not appear at that time. A 30-day suspension letter was ordered to be sent. Mr. Curvin apparently contacted the clerk's office following at some point in intervening and requested hearing. So we're here today for first appearance. Mr. Curvin, you are charged with driving without a valid driver's license or no DL. That is a Class B non-person misdemeanor. A B misdemeanor is punishable up to 6 months in the county jail and a fine not to exceed $1,000. Not saying that's what the penalty will be. It's just what the maximum available under Kansas law. You have the right to a trial if you are subject to a jail sentence, or if that's a possibility, then if you wish to have an attorney but could not afford one, you could apply to the court. If you met the financial guidelines, then I would appoint an attorney to represent you. However, if a person is not facing a jail sentence, then they're not entitled to court-appointed counsel. We'll take that up as go further. Additionally, at a trial, you would have the right to be presumed not guilty. The state would have the burden of proof of beyond a reasonable doubt. You would have the right to cross-examine the state's witnesses. You have the right to call witnesses on your own behalf and to utilize the court subpoena power to make sure they attend. Additionally, you would have the right to testify or not testify as you see fit. If you chose not to testify, that could not be used against you in determining if you're guilty or not guilty. You understand your rights, sir?
I do. Yes, sir.
In a moment, I'm going to ask how you wish to proceed in regards to a plea. Right now, do you have a plan in regards to an attorney? Are you hiring an attorney, asking the court to appoint, representing yourself?
Represent myself, Your Honor.
Very well. Mr. Curvin, you looks like you're 33 years old. So absent some other compelling reason, you'd be able to represent yourself. If you wish to, I'm going to ask what your plea is. If you wish to have a trial, if you wish to, I don't know if you qualify for a diversion, if you wish to try to get the case resolved either through counsel or yourself with the county attorney's office, any of those things, then your plea should be not guilty. If you choose to plead guilty, then we would proceed to sentencing. I would hear from both parties in a pronounced sentence. If you plead no contest, that is then if the state were to present what we refer to as a proffer, a person who's pleading no contest are not challenging the charge, but they're not pleading guilty per se. If there's a proffer that supports the facts that would result in a guilty verdict, then that person would be found guilty and we'd proceed to sentencing in the same manner as I described before. With those things in mind, how do you wish to plead? Guilty, not guilty, or no contest?
Are we on the record?
Yes.
So on the record before I make a plea, I'd like to simply state that I do not understand the nature and cause of the action in regard of the elements of my personal jurisdiction, the venue, and the nature cause of action until the prosecution has properly alleged them for me, and therefore I'm not able to enter a plea until then. I'd like to know if it's going to be if I'm going to be tried under common law, or is it going to be under merit-to-amity law?
Can you speak up a little bit? It's difficult to hear you.
I got my headphones on. Did you hear what I said, or just what part did you need to?
I heard part of what you said. So.
Okay. I was saying, for the record, I did not simply understand nature and cause of action brought against me, with regards of the elements of our personal jurisdiction, and also the nature cause of action until the prosecution has let me know what they're going to try me underneath, so I can let you know what I'm going to make my plea. I'm not really sure if it's under common law or is it merit-to-amity law. So I can know how to defend myself, and then I can enter my plea.
Have you filed a motion for discovery in this case?
I filed in I put a special appearance in affidavit in about a week ago.
Well, there's something that's listed as correspondence in the court file. I'm looking at it now. It's not an official pleading. Neither does it state that you've requested information from the state that we refer to as discovery.
You didn't receive. I emailed. I actually faxed the special appearance. Did you receive it?
There's a document that looks like it is served or before a notary in Oklahoma that reflects what appears to be your signature. It says respondent beneficiary of the named defendant in constitutional rights / benefits.
It should
Is that
be like
the document you're referring to?
Yeah, I think is it just only one they went through? Because there's like 4 pages, 4 or 5, a few pages that went through, not just one.
There's a 1-page document.
There's only one. It's supposed to be more. I faxed to more over there. It was supposed to be like 4 pages.
It's 1 page. Where it begins is at the top. It says the Supreme Court said in U.S. versus Meinecke.
Yeah, I have a copy right here with me. I think you're just referring to the last page, and I sent like 4 pages of them. I think I got it notarized at the end of it, and I think the notary already sent the last page to you, but it was supposed to be 4 more pages to go with that. And that was the special appearance.
All right. Are you entering a plea of guilty, not guilty, or no contest?
I cannot answer a plea at the moment because I'm not sure what I'm going to be tried under. What jurisdiction am I going to be tried under? I do not understand the nature of the cause of action brought up yesterday.
Well, I've explained what you're charged with.
Yes.
I'm going to put you down as a plea of not guilty and set this matter for trial. If you wish to
because my special appearance didn't make it. I need to resend that as well. How can I reset it? So I could have a chance to resend my special appearance because it didn't make it into. I guess you only had the last copy of it. There's more pages that you didn't receive. I need to enter that in beforehand. How can I reset it so I can do that? I have time to do that. I can do it today, and we can reset it for this same time next week if that's okay with you.
I'm going to go ahead and set this for trial. You can, if you have pretrial motions that you'd like to address, they need to be properly filed.
Okay.
Sometimes if people are representing themselves, they're still held to the same standard as an attorney would be.
Yes, sir.
And sometimes people don't have the experience to do that correctly. So there's an advantage to having an attorney. But I'm going to set aside 2 hours for bench trial.
I'd like to be tried by jury if that's okay. If I'm going to be separate trial, if it has to be separate trial.
Have you made a written request for trial by jury?
I have not. This is my first appearance today.
If you're seeking to have a jury trial, then you're going to need to file a written motion in that regard.
Okay.
Again, pursuant to Kansas law, there are restrictions in that regard. When we set a jury trial, I generally have a pretrial date that we have. You will be required to be here at Elk County to conduct that hearing. If you have pretrial motions that you're wishing to have heard, we typically would do that in advance at a pretrial. I'm going to set a pretrial date at this time. It'll give you an opportunity to place your written motion for request for jury trial. We will set that hearing for, Sarah, can you give us a date within 30 days?
How long would you like for the pretrial, sir?
Anytime is fine before the 17th.
Hour.
That's about 1 hour. Okay.
Miss Gillette, on the 17th, do you have very much scheduled with Satterfield for your half day?
Can I do another day besides the 17th? I can't make that day. I have something on that day. Is there maybe the 15th or maybe after the 17th? That's the one day I cannot make.
We could do the morning of May 1st at 9 a.m.
Okay.
So May 1st at 9 a.m. That will be in person at the Elk County Courthouse in Howard, Kansas. You'll need to appear at that time. You'll need to have your pretrial motions filed, including your request for a jury trial. At that time, if everything's in order, we'll set a trial. Counsel, anything further?
Not on Mr. Curvin, Judge.
Mr. Curvin, anything further today?
No, Judge.
Very well. With that, we are adjourned.
To practice. Good day.
Are you here to stop?
I do not. I stopped.
Sure
I pulled over to let you around.
No, your plates are dead.
I pulled you over to let you around.
I'm telling you, your plates are expired. Now I got you stopped. That's what I'm trying to tell you. You've been expired since May.
Do you have me? You're detaining me.
I need to see your driver's license.
Why am I being detained? Am I being detained?
Inspection sticks are dead. Your plates are dead. You're not being detained. You're on a traffic stop.
Turn your phone on. That's all right.
I need to see your driver's license, your registration proof, insurance.
Is that an order?
No, that's a direction from a police officer.
Are you ordering me to do something?
From a command of a police officer, you have to present your driver's license. That's state law.
Am I required to?
Yes, you are.
Do you have evidence that I'm required?
I'll tell you what. I'm going to ask you again. Then we'll get back up and we're going to arrest you. Show me your driver's license. You have one?
Is that a requirement?
You have a driver's license.
Are you ordering me to do a thing?
606-601.
You can call whoever you want. Are you giving me an order?
Yes, I am.
Do you have the authority?
Yes, I do have the
Under what?
authority.
Under what
Who are you?
authority?
I need your assistance across from the football field.
Why are you detaining me?
606 headquarters. I'll be on a traffic stop across from the football field.
Am I free to go? Am I free to go? Why are you detaining me? Why?
Because your plates are dead and I need to see your driver's license.
Am I required to have?
I told you, you are required by law.
How do you know that?
Because the State Police Academy, 39 years of training, 39 years of being on the job, that's why I know.
Okay.
Let me see your driver's license.
Is that an order?
That's an order.
If I present you with a thing,
Present me with your driver's license.
can you use it against me in court?
Depends on if they're expired, depends on if they're suspended, depends on if they're...
I don't have to say anything to you, actually. I know my rights. I know my rights.
What's that?
I know my rights.
I'm not violating your rights. I'm asking you for
You're
your
detaining me
driver's
with no reason. Have I harmed it? Have I caused any other person harm, injury, or
I have no
loss?
problem with you.
Have I committed a
Other
crime?
than the fact you're not giving me your driver's license.
Is there a crime that I've committed?
If
Have
you-
I committed a crime?
If you don't present your driver's
So
license,
no,
that'll
I-
be a crime. That's a forthwith violation. You
So
will
I
go
haven't
to jail.
committed a crime.
You will go to jail.
Why do you have me pulled over? I haven't done
Because
anything
your plates
wrong.
are expired.
That's why you pulled me
I've told
over?
you that. Yeah.
For what?
I've told you that.
Am I required to?
You keep saying the same thing over and over.
So
yes,
do
you
you.
are required.
So do you. That's what I'm going to keep doing.
You keep saying the same thing.
Am I allowed to say what I wish? Am I not allowed to?
Yes,
say
you're allowed
what
to
I
talk
wish?
all you want to. But I'm allowed to ask you for your driver's
Are
license.
you also allowed to use it in court against me? Are you allowed to use it
Do you
in
have a
court?
driver's license?
Will you use it in court
You must
against
not
me?
have one.
Will you use it in court
Do
against
you have
me?
a driver's license?
You're making assumptions.
Huh?
You're making assumptions.
I don't have to
for-
answer any of your questions.
Well, don't.
I don't have to follow that
Why
command
such
either.
a hard? Why such a hard line here?
Why do you have me stopped from doing what
I just
wish
told
to
you.
be doing?
I've told you 10 times.
Have
your
I-
plates are dead.
Have I
Your
harmed?
plates are expired.
Have I committed a crime? Have I committed a crime?
606 headquarters. You run those registration. Did you run that? Are they expired?
Why is he asking if they're expired? I thought he knew.
What's going on?
Hi there.
He refuses to present his driver's license, and he thinks I have no reason to stop him.
I don't think I didn't say
Your
anything.
driver's license.
I beg your
I'm
pardon.
Chief Harbert. Don't beg my pardon. You have to give him your driver's
What
license.
is going on here? Are you public servants? Are you public servants?
I'm the chief of police.
Are you a public servant?
You either give him your driver's
Are
license
you a
or you'll
public
come out of the
servant?
car.
All right. Are you a public servant? Are you a public servant?
asking
Are
you
you
a
a public
lawful order.
servant? Are you a public servant?
He's asking you a lawful order. You either follow the lawful
I'm
order or
asking
you'll
a
be
question.
removed from your vehicle.
In what
You
fashion?
understand?
606 headquarters.
You get the registration back. Registration 5 of 20.
I'm not required to do
You are
anything.
required by law. It's a lawful order.
What is your authority?
I'm the chief of police. Don't pull this crap with me. You will be brought out of the vehicle if you do not follow lawful orders.
Very violent.
You're being real violent.
I'm not being violent.
Yeah,
You're
you
being
are.
raising-
disrespectful and not following the law.
We don't need to say anything.
See if you can use that name, run that name, and you get some information on it.
Yeah.
Don't lock your door.
Is that an order? What authority do you have to give me
I
an
have
order?
authority.
I
Don't pull this
work-
crap.
What kind of authority? All
Authority by the state of West Virginia.
Yeah? To do what? Serve the public? Or to harass me on the side of
Nobody's
the road?
harassing you. You were stopped by my officer lawfully.
I stopped
Your
to
vehicle's
let him
also
around me.
I told him.
not legal.
He's been
What
advised.
does that mean?
Don't give this crap. What's it mean?
What does that mean? Tell me what it means. I don't
Your
even
name
know. I don't know
Michael
who
Ray?
you
Is your
are.
name Michael Ray?
I don't know who you are.
My name's
You know
Officer Mike
exactly who
Campbell.
I am. The chief of police of Shinnston. I told you.
Let's see your driver's license.
Is that a requirement
Let's
or
see
an
your
order
driver's
from me?
license. Yeah, it is a requirement.
Am I being detained?
Yeah,
Yes,
right
you
now
are.
you are, yes.
Have I
And you're
committed a
about ready
crime?
to be arrested.
Have I
Right
committed
now, yes, you're committing a crime. You're denying a lawful order.
Headquarters 666, have an approximate age on this subject.
So you're going to push your luck where you're going to go to jail instead of just giving him your information.
Okay, and he appeared to be in his 20s, 30s, 40s, 50s.
If I give him my information, is he able to use it against me in court?
He's not going to use it against you in court. What he's doing is going to run it and make sure everything's valid. Is your driver's license not valid?
You're not answering my question.
I said, is your driver's license not valid?
If I provide any information,
What's going to be used against you in court is what you're doing right now is called obstructing. And I'm going to arrest you here in about 2 seconds
what
if you
am
do
I
not comply with the
obstructing?
lawful order.
Why are you getting so angry? Have I committed a crime?
You are right now. You're obstructing. You're obstructing an investigation what this traffic stop is. Laugh all you want.
What are you
don't think I want to
investigating?
arrest you. The traffic stop is considered an investigation.
Why am I being detained?
You got 2 more seconds before you're arrested for obstruction. So give the driver's license or you're going to be arrested.
Under what authority? Sir, get your hands out of my car. Get your hands out of my car.
This is
Get
very
out of here.
illegal.
Get your hands out of my car. Don't tase me. I didn't do anything.
You were given a lawful order.
Open the door.
Please
Open
film
the
all this.
door. You are obstructing an investigation. Film all you want. It's on video already.
We have not done anything.
You were stopped on a lawful order. Now open your door.
A lawful order? What are you
Open
talking
your
about?
door now.
Is that an order?
Yes, it's an order. Open your door.
Call us. We gotta call the police.
You're obstructing an investigation. Open your door.
What about the
You
sheriff?
spitter.
Reach in a bag.
We're not reaching in the
You're
bag.
not reaching anything.
He's getting a bottle.
Open your door.
Get that thing pointed away from my
No, it's a
face.
taser.
Get out of the car.
This guy.
This is
out of
unbelievable.
control.
This is
Out of
unbelievable.
Get out of the
control.
car.
Is that an
Unbelievable.
order?
Yes, it is.
Under what authority?
Mine. Now get out of the car.
What authority are you doing
Get
this
out of
under?
the car.
You can see both all of our
These
hands.
These people
and
can see.
everything.
These people can see. We're not doing anything wrong.
We're not doing anything wrong.
Get out of the car.
We're not doing. Hey,
Get out of the car now.
sir,
Get out of,
get
the
out of
car.
my car. Get out of my car.
Get out of the car.
This is
Out of my
breaking and
car.
entering. This is breaking and entering.
Out of the car.
I'm done. Ow! Ow! I can't. Oh!
Out of the car. Out of the on the car. Bobby.
You piece of you.
Hey!
Do you see this? Do you see this? This is. Hey, I'm not doing anything. I am not doing a thing.
You get back and you
I'm
stay
not doing
back.
a thing.
You were trying to grab him.
I'm not doing it.
You were trying to grab him.
You see this breaking and entering?
You're under
Hey,
arrest.
hey, hey, hey,
Out
hey.
of the car now.
Hey, whoa, 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 whoa! I'm coming.
Out of the car.
Hey, I'm coming. I'm coming.
Oh, man. Behind your back now.
I'm not doing anything.
Drop the phone and put your hand behind your back. You're under arrest for obstructing and destruction of property.
Oh my God. God.
When they give you a lawful order, you follow it. You understand?
Oh man. There's probably some tissues in there or something. We're not doing anything wrong. Man.
Stand right there.
Oh my God.
Bring your feet. You have anything?
Hey, help out,
stick,
man.
Anything like that?
We've done nothing wrong. We're doing nothing wrong. Please watch. Help, man.
Watch your head. Watch your head.
You put me here.
Oh, God, oh!
Get up. Here, help you out.
Oh!
Here.
Come on, man. Ah! Hey! Hey, man. My dog is in this car.
I'm not threatening you. Say one more word and that's 30 days. 30 days.